Hello, everyone. Yesterday, we talked about the I-130. Today, I wanted to continue talking about this very important application. I'm going to explain what happens overseas with your relative once the I-130 is approved. My name is Raluca Hanea. I provide immigration, estate planning, and family law services to my clients in Lawrenceville, Georgia. Here with me is Nina Clear, my marketing and office manager. We really appreciate all your likes, shares, and comments as they help others to see our videos.
And just to let everyone know, some of this may be a repeat from yesterday, but we want this video to kind of be a standalone. So we don't want to make you have to watch the other one to understand what we're talking about here. So if you can explain again what the I-130 is.
Sure. The I-130 is a petition that you file to show the relationship that you have with a person who is not the U.S. citizen or green card holder that wants to immigrate to the United States.
And what is the title, or how are you known if you are the person filling out the application?
They are called the petitioner or sponsor.
And the title of their relative that they are applying for?
They would be called the beneficiary.
Okay, and as we discussed previously, this application, the I-130, usually must be filed in the United States, right?
That's right. There are exceptional circumstances, such as being an active duty service member, that allow someone to file overseas at the consulate, but the majority of the applications, the applicants, they must file here in the U.S.
And you said yesterday that I-130 is the first step in obtaining a green card for your relative, but that is not all that you need to do in order to get a green card, right?
Right. It seems confusing to people. The I-130 is filled out and is filed as a first step when you apply for a green card, but its approval does not give you a green card. Basically, it says that your relative, spouse, sibling, child, or parent is approved to get a visa, an immigrant visa, to come and stay in the United States. But now we, meaning the immigration agency, we will process their green card application.
And you usually have filed the green card application at the same time that you filed your I-130, right?
Usually, yes, if the beneficiary is living here in the United States. As I mentioned yesterday, that is called a concurrent filing. But if they are outside the United States, if they live outside the United States, the State Department has additional forms that you will need to fill out.
And as a reminder, when you file the I-130, you usually submit supporting documents with it, right?
Yes. And typically when you are filing for a spouse, you must prove it is a bona fide marriage, so you will need to submit documents supporting that claim. If it is another relative, you may have different supporting documentation you will need to file.
So you submit the I-130, and then USCIS sends you a receipt that they got it, and then what?
Then you wait. After it is processed, you will receive an official I-130 approval or denial.
And if you receive a denial, can you appeal that?
The denial will include the reasons, and they will tell you if you can appeal it.
Okay, and say you receive an I-130 approval, what happens when your spouse or relatives live outside the United States?
First, USCIS will forward the approval to the National Visa Center, or NVC, and NVC will then begin coordinating the interview process at your relative's local consulate. If there is no attorney of record on file, you must file a DS-261 online, which basically tells NVC how to keep in touch with you. And then your relative will start the application for the green card.
So they won't file the green card application until that point.
Right. And this is slightly different than for relatives who are here in the U.S. when the application is filed, who can file them concurrently, as we talked earlier. So with the green card application for overseas relatives, there is an online immigration visa application that you must file.
And what information do you provide in the application?
There are a lot of information that they ask you, and it includes information about the petitioner, about you, about the beneficiary, your relative, or derivative beneficiaries, who can be children of the beneficiary under the age of 21 who are unmarried, and where they also ask where this relative is going to live in the US and how and who will support them.
And do you submit anything else?
You need to pay the consular fees, and after they are paid, the petitioner must submit the supporting documentation to the NVC. Also, each consulate has its own requirements.
And how do you submit the supporting documents?
These are sent to the NVC in the United States. The documents required by the consulate must be submitted before the interview or brought to the interview. The consulate will notify your relative as to when they want the documents. An example would be your medical examination results, which you bring with you at the interview.
And then what happens?
Your relative will be put in a queue for an interview to be scheduled.
And how long does that usually take?
It really depends on the consulate. Some, it happens within 4 to 5 months after NVC receives the I-130 approval, and some take longer.
And just to make sure everyone's clear, the interview is scheduled at the local consulate or embassy.
Right.
Okay. And do they need to bring anything more than like the documents you already mentioned?
Yes, they must bring their government ID, which is usually their passport. They will have received by then a letter with the date of the interview, and it should have a list of what they need to bring. So be sure they follow that list and bring everything listed.
Okay. And I know here when they have an appointment at USCIS, they get a letter with the interview date and time. They have to bring that in order to be allowed in. Do they have to bring that with them to the consulate? Do you know?
I'm not very sure, but probably yes.
Okay. And do they need to bring originals with them?
Yes, because the officer will want to see the original. But just as with interviews at USCIS here in the United States, be aware that if you give them the originals, you may not get them back. So be sure you have backup copies that you can give the officer to keep the copies.
Okay. And can an attorney go with your relative to the interview at the consulate?
No. I have prepared people for their consulate interviews before, but they must attend them alone.
Okay. Do you have to have the medical exam prior to that interview done?
I was thinking that you can also go with the petitioner. So if the petitioner wants to go to the interview with their relative, with their beneficiary, they can go.
Okay,
even
so
if they don't have an attorney.
So the person who applied for them could go with them, but not an attorney. And
Not
do they
an
let them
attorney.
in to the interview with
Yes.
them? Oh, okay.
Yeah, because they are part of the same application.
Okay.
So
Back to the
what
medical
was-
exam.
Yes,
Sorry.
what was your question? I'm sorry.
So do you always have to have your medical exam before your consulate interview?
Yes, and you should bring the packet from the doctor, which is an envelope that's unopened, with you to the interview.
And then you have the interview,
Mm-hmm.
and then what happens?
They will usually give you a letter at the interview telling you if you are approved, or if they need more information, or if you were denied. If you are approved, you will receive an immigrant visa stamp on your passport, and they will give you a visa packet. And do not open this packet. You will need to, you will also need to pay an immigration fee online, which you can pay after the interview when you're approved, or you can pay when you come in the United States.
Okay. And then you said don't open the visa packet. What do you do with that?
You need to bring that packet with you in the US and give it to the customs agent. they will review it and determine if you're allowed to enter the U.S.
And when will you get your green card?
If you paid the fee, as I said earlier, if you pay the fee before arriving in the U.S., you will get the green card within 45 days of arrival.
So if you pay it when you get here, it sounds like it might delay you
It might
getting
delay
it?
a little bit.
Okay. And then back to the most often asked question, how long is this going to take?
And as usual,
It depends.
it's usually, I'm going to say it's impossible to say. There are so many variables, and USCIS will usually take about 3 to 4 months to approve the I-130. Then the NVC will take several months, and then you have the consulate scheduling the interview. So for most clients, it is probably from 1 to 2 years. We talked about how long this could take and how to check in a different video, and we highly recommend that you watch that as well. And we'll post here a link to that. And in that video, we give step-by-step instructions on how you can check how long it takes. If your relatives are not in the US, the category that gets approved the fastest is green card holders applying for their spouses and their unmarried under 21 children. And we find this interesting that overseas green card holder immediate relatives seems to be processed more quickly than the US citizens' immediate relatives. So for this fastest category, it takes about 2 years.
Okay, and is there anything that you can do to make it go faster?
As with most immigration applications, fill out the forms fully and truthfully and provide any requested information as quickly as possible, and notify the NVC and the consulate of any important changes such as address, age, or marital status. Thank you again for watching. We really appreciate your likes and comments. If you have any questions, please reach out to us as we're always here to help. Bye-bye.